Welcome to UCounsel. The Ontario Court of Appeal has recently released a decision in a case called Waksdale versus Swigan, North America. The case is fundamentally about interpretation of termination clauses in an employment contract. The court has provided guidance on what clauses it will consider enforceable and what clauses it will consider unenforceable. So the case has huge implications on termination clauses, and in turn it has huge implication on employees' termination rights, severance rights at the end of their employment. So in today's lecture we will explain how the court's decision has changed the landscape of employees' termination rights based on the termination provisions in their employment contract. We begin with our usual disclaimer that this lecture is not legal advice, so if you have any specific questions, you should contact a lawyer or a paralegal or the Law Society of Ontario for a referral. Now, if you have watched any of the previous lectures, you have some basic understanding of what are an employee's rights on termination. Fundamentally, the employee's rights are common law rights. Whether an employee is terminated with cause or without cause, the common law rights fundamentally by default would apply. Now, in a without cause termination, which is essentially a no-fault termination, the employee has done nothing wrong, the employer has just decided to terminate the employee's employment because of the change in their business structure or for any other reason, but nothing to do with the employee's performance or any wrongdoing on part of the employee. Now, when common law rights apply to a termination of employment for an employee, usually the rights that the employee gets are the highest. So they could be as high as, up to 24 months of severance in certain cases. But there is no formula for figuring out these common law rights. The court will consider an employee's age, his or her position, length of service, chances of finding another job, and then there are many, many other factors that the court may consider in deciding what is the appropriate common law notice, what is the appropriate severance for that employee who has been terminated. So that's sort of the common law right on a without cause termination. If the employer is claiming that employee had done something wrong, some major infraction on part of the employee, then it's a high burden for the employer to prove cause in common law, but that must be proven for an employer to be able to sustain common law dismissal on a cause basis. Common law rights are fundamental and by default, but these common law rights can be displaced by contract. So an employment contract can change these entitlements for an employee on termination, which is what happens in many employment contracts. So what happens in an employment contract? Usually an employer will provide a termination clause. There is a specific clause that deals with what an employee's rights will be on termination, and that will be put in an employment contract. If an employment contract does not have a termination clause, then the fundamental rights, the default rights, common law would still apply. So it's called the rebuttable presumption, right? So an employment contract can rebut the presumption of common law rights. So if it is not specifically rebutted, if there is no specific clause in a termination, no specific termination clause in an employment contract, then the rights will still be common law rights. But one thing you want to understand is that not every termination clause in an employment contract is enforceable. So it is not sort of the general theory of contract that whatever two parties agree, the court will enforce it. That doesn't happen in employment contracts. There are circumstances in which there is a termination clause in an employment contract, but the court will not enforce it. And in fact, majority of the litigation with respect to severance rights and termination rights is about the enforceability of those termination clauses. So why could a termination clause may not be enforceable? One of the reasons could be that the termination clause violates the Employment Standards Act in Ontario. If you are in a different province than that provincial legislation, if the termination clause violates that specific provincial legislation, then that termination clause could be considered unenforceable. So one of the things with respect to ESA, Employment Standards Act in Ontario, is that an employer and employee cannot contract out of the ESA. So employer cannot ask you to agree to rights that are less than ESA or rights that are contracting out of the ESA. So another example is providing rights that are lesser than ESA. In employment contracts, the employer cannot ask you to contract out of the ESA. If it does so, then that particular termination clause will be considered unenforceable, and what that means is your common law rights would still apply. Another example could be that the termination clause is ambiguous. It has different it is open to different interpretations, and therefore because of the ambiguity, the court will say that the clause is unenforceable, and therefore common law rights would apply. So just sort of a recap of this, common law rights are the default rights, but they are rebuttable. There is a presumption that it could be rebutted. How can they be rebutted? By an employment contract, which creates its own rights, termination rights. But for employment contract to be enforced, the termination clause needs to be enforceable. If it is enforceable, then employment contract rights will prevail. But if the termination clause is unenforceable, it's because it's ambiguous or because it violates the ESA, then you go back to common law rights, which are the default rights for an employee. In an employment law litigation on termination, the majority of the fight, majority of the dispute is here, where the employee is trying to show to the court that the termination clause is unenforceable because of its language, because of its violation of the ESA, or whatever the argument may be. The employer is hoping that the termination clause is considered enforceable so that employee gets lesser rights than common law. So that's sort of the most common battle between an employer and employee in their litigation when a termination of employment happens. In employment contracts, there are two kinds of termination clauses. One is without cause termination clause, and second is with cause termination clause. Most employment contracts have both of these clauses. They are separate clauses. One is without cause, one is with cause. A lot of employment contracts may only have one clause, which will be without cause termination. They may not have with clause. But most employment contracts will have both. Without cause will deal with termination of employment when an employee has done nothing wrong, but the employer has decided to terminate the employment. With cause is when the employee may have done something wrong, in which case the employment contract may define what would constitute cause. It may be negligence of duty, maybe theft, maybe coming to work late. All kinds of scenarios may be given as an example which would constitute cause. Before this decision came out, what happened was that these two clauses were considered separate clauses by courts. So without cause is a separate clause, with cause is a separate clause. They're dealing with termination, but in two different scenarios. So if one clause is unenforceable, it would not make the other clause unenforceable. So for example, if with cause termination clause was unenforceable because of the language that was used in that clause, but without cause was fine, and if the termination was based on a without cause dismissal, then the court will apply this particular clause because both clauses were treated separately. That has significantly changed because of Waksdale versus Swigan decision, and the court has said that termination is termination, whether it's with the cause or without cause, whether you put it in two separate clauses, we will consider this as one clause. We don't see any difference between the two with respect to them being relating to termination. So if with cause termination is unenforceable, the entirety of the termination clause would fall, which means that the employee's rights will be going back to common law rights. And in this case, this is exactly what happened. In this case, there were two termination clauses in Mr. Waksdale's employment contract. The without cause termination clause was valid, was properly drafted, was enforceable. The with cause termination clause, however, was unenforceable because of its language, and parties had agreed that this is the correct interpretation of the clauses. Now, Swigan North America argued before the court that because Mr. Waksdale was terminated on a without cause basis, this clause should apply. And at the first instance, at the Superior Court of Justice level, they were successful in that case, but Mr. Waksdale appealed the case all the way to Ontario Court of Appeal, and Ontario Court of Appeal agreed with him, and they basically said, no, this is all one big termination clause, and because the with clause termination clause is unenforceable, the entirety of the termination cause is unenforceable, and so the common law termination rights would apply. The case has huge implications. Why? Because majority of termination clauses in employment contracts would now be considered unenforceable because of the way the lawyers have drafted them. They were not concerned about the enforceability of both clauses together. So majority of the clauses, especially with cause, were not considering the argument that was raised in Waksdale case. And so when those clauses, if they are argued before the courts based on this case, they will be considered unenforceable. So the employees would have significant rights based on common law. They will not be getting rights that are limited in those employment contracts. So there's a huge advantage for employees because of this case, and there is a significant disadvantage to employers because their employment termination clauses will not be considered enforceable in majority of the cases. And so what is going to happen now in the coming months is that employers will be trying to redraft the employment contracts and ask their employees to sign new contracts so that they could abide by this new case, and the employees may have that opportunity not to sign those agreements or renegotiate their employment contracts at that stage. So a lot of that is going to happen in the coming months. Thank you for watching.